Good morning, this is Senate Judiciary, Tuesday, February 27th, 2024. And we're first taking up a bill that is not in this committee, but of interest to the committee is S-192 that has to do with the forensic facility. Both Senator Lyons and I served on a summer study committee called the Act 27 Working Group. And it was working, a lot of work. And there are some issues here that I think the Health and Welfare Committee has done a terrific job on. But there's some that we should review, particularly the victim notification pieces, as well as how to remind us that these are individuals who have developmental disabilities who may have committed a very serious crime like murder, and should they be allowed to be in a forensic facility versus being held in jail awaiting competency hearings or whatever. So that's part of the bill. Senator Lyons can explain the bill, but also perhaps the victims piece, which we've got to us.
Yeah, thank you. So for the record, Senator Jenny Lyons, and as Senator Sears indicated, the Act 27 asked for a working group over the summer and fall to look at the issues that are in the bill, and specifically to look at the use of or placement of folks with an intellectual disability who have committed a significant crime, or folks with a mental illness, also incompetent to stand trial, placement in a forensic facility. So the work that we did over summer and fall was very challenging because there's so many. This is a new discussion in many respects for folks with intellectual disabilities, but I'm not going to go through the bill thoroughly with you because it's not complicated, but it is complicated. It probably wouldn't be for you as much as some others. But so just to talk briefly about who is affected in the bill. If you look at page 2, really, there are, beginning on page 1, the bottom of page 1, this is placement of individuals at a forensic facility who present a significant risk of danger to self or others if not held in a secure setting, and they're charged for a crime for which there is no right to bail, and in your area, your jurisdiction under 13 BSA, and so they're charged, present a risk to themselves and others, no bail, and are found not competent to stand trial due to mental illness or intellectual disability, or were charged with a crime for which bail is not available and adjudicated not guilty by reason of insanity. So those are the conditions for placement in a secure residential facility. The important piece in the bill for us as well is that placement be for treatment be in a facility that is the least restrictive setting, and that's throughout the bill as well. So as we looked through the bill and we talked briefly, we worked long and hard on this, not just with the working group, but also in committee. We looked at commitment, recommitment, and placement. So commitment to the Commissioner of Mental Health, or commitment to the custody of Commissioner of Dale. We looked at recommitment and when that might be necessary, or we also looked at placement and when placement in a secure residential facility might be indicated. And then we also looked at discharge from placement and commitment. So it's along a series of how the individual is treated within the system. So there are secure residential facilities, there's residential placement for those folks with intellectual disabilities as well. There are other placements for folks with issues around mental health. One of the concerns that came to us very quickly from the victims, and really the mothers of two victims in particular, one from my district, Burlington, and one from Bennington, is that victims need to be notified. And when we define victim, we take it out of VSA 13, which includes family. And it became very clear that victims need to be notified when when commitment occurs, when placement occurs, when consideration for recommitment occurs, when discharge from the placement occurs, or when a discharge from commitment occurs. So we went through the bill, and it was very clear that we had that in the bill for those folks with intellectual disabilities. And I'll just step back for a minute and indicate that the language that's here is very new for folks with intellectual disabilities who might be involved in this type of crime and be eligible for commitment to a secure residential facility. So that language was new, but we also looked at the language for folks with mental health issues and tried to mirror that. As we went through the bill, we ensured that victim notice was in for folks with intellectual disabilities. When I went back and reviewed the bill over the weekend, and I also heard from one of the victim's mothers that she was concerned that the language wasn't clear for folks with mental health issues. And so so it was a busy weekend. I reached out to our ledge council and also to the Department of Mental Health to determine whether or not victim notice was as robust as we wanted it to be. And in fact, it's not in the bill as we would like it. So this morning, our committee reviewed a proposal of amendment that will add victim notice in a more robust way for folks with mental health issues. So and I'm happy to provide you with that proposal amendment. It will be going up on the calendar. Well, the bill is now in appropriations, so the amendment will could follow the bill.
Senator Miles.
So questions that you have, I think it's better if you ask questions rather than my going through the 30-page bill. Overview is we have folks who are incompetent to stand trial, have committed a crime as defined in 13 VSA that doesn't require bail, and have either an intellectual disability or mental health concerns.
How does the victim notice interplay with HIPAA and the patient's rights to privacy?
Yes, well, that's a very good question, and we've been reassured that the process is such that it will adhere to that. And that's, it's a good question. So obviously, for my, I guess, if you think about it, the individual will be notified that the individual with a mental illness will be either recommitted or will be discharged from either commitment or placement or commitment. And that's it. There isn't a request for hearing, rather there's, I'll give you the language exactly. There's not a, I just finished this morning, so you'll have to bear with me. And so a victim receiving notice pursuant to the subdivision relating to what I've been talking about has the right to submit a victim impact statement to the Family Division of Superior Court in writing, or through the state's attorney or Attorney General's office. So it's an impact statement. It is not a request for hearing. So that would then preclude the exposure of sensitive medical information. I believe that would do that.
Yeah, it's just, I know, and just from my own practice, like I can't even disclose if someone is receiving treatment. If someone calls and says, hey, is so-and-so a patient there, I can neither confirm nor deny that. So it seems like it sort of pushes up against that line, but so I just want to make sure we're covered.
I think so, and it would be helpful perhaps to hear from Karen Barber from Department of Mental Health, who worked on this language to ensure, I believe that at least part of the intent on her part and on Department of Mental Health was to ensure that there isn't a violation of patients' rights with respect to medical information. Yeah.
Any other questions for Senator Lyons? Thank you so much.
Well, thank you,
And
we'll get you the
thank you
amendment will be out, so you'll be able
yeah,
to see that.
thank you for the hard work on this bill.
I will say that this bill has been a challenge for a number of reasons, not the least of which is what Senator Bajowski has asked about. And that's for the mental health side, but on the disability side, it's very clear that folks with intellectual disabilities react very differently, and whether the treatment is significantly different, it's not easy. This is not easy. So when you think about the individual who is in the criminal justice environment, who doesn't understand, it's difficult. At the same time, we want to do right by victims and their families.
The testimony during the summer study was compelling from the Department of Corrections, by the way, that I think is important to keep in mind here. Individuals with intellectual disabilities who end up in a Department of Corrections facility are some of the most difficult for them to deal with. It's not their general bailiwick, it's not something they understand. But they're also very vulnerable to being taken advantage of by other inmates who are obviously adept at.
You're right. I mean, what we kept saying throughout the summer is the alternative to a place where treatment is available is jail, where they become objects of abuse and without treatment.
The other point was that on detention, individuals in this category tend to stay a lot longer than others who are on detention, because really the state has no place, doesn't know what to do with it, and it takes a long time to get the competency evaluations and other things done. So, I mean, those are the real alternatives. And it's stark. It was stark. That testimony from DOC's line staff was really
significant.
Anyway, any other questions for Senator Lyons? Thanks so much for taking time with us, Senator, and
thank you.
Get you back to your merry little band next door.
Oh yes, we're going to have some fun this morning. Thank you.
Is it as hot in your committee room?
Oh, no, not like this. This is like a little sauna.
I know, I don't know what's happened. Maybe we could shut those blinds and at least keep.
We turn down the temperature, so.
Well, the temperature's down to
Oh, really?
off, but
I think the
Time to
old
open the
thermostat has a
windows.
hard time keeping up with the drastic swings in temperature.
well, we could always take the storm windows, or we did that years
I
ago.
used to take
and
my
got
classes
everybody
outside,
upset.
you know.
Huh?
I used to take my class outside.
Yeah, you could do that.
Yeah.
Are we moving committee to outside?
But it's hard to do Zoom outside. We've got witnesses on Zoom. The next witness is Karen Barber from the Department of Mental Health. General Counsel for the Department of Mental Health. Karen, welcome.
Good morning. Thank you for having me. For the record, Karen Barber, General Counsel of the Department of Mental Health.
I'll keep my testimony very limited, just happy to answer questions. I just want to touch on two things, which I think are related, which was the victim notification piece and then that related HIPAA question. So the reason originally we hadn't put any extra protections in for victims notifications is we felt like the language was already there, but we definitely heard from victims that they felt it needed to be stronger. So we did, I did work with them yesterday, and we have the language that I think is up on your webpage that I suggested, but is also in the version of the bill that I think is also posted on your website. And that directly relates to the question around HIPAA. So one of the things about individuals in our custody is there's two things that actually protect their protected health information, right? Not just HIPAA on a federal level, but there's actually a Vermont statute, 18 VSA 7103, which adds extra protections. And so several years ago, when we talked about adding a notice provision, we had a lot of discussion about HIPAA and could we notify? And HIPAA does have a by law exception that allows you to give, to break confidentiality in certain limited, narrowly tailored circumstances. And so what we felt like was that when there were cases where someone had been found incompetent or insane and was being released from a secure setting or out of our custody, we could provide notice to the victims. And so we did have that in there, right? It's that was several years ago, I can't remember what, but so that language already exists. We are doing that. And so what we've done is just simply add the forensic facility to that. And because it's very limited, we felt like it was an allowable exception under HIPAA. The other thing is we're giving notice to the state's attorneys. Again, there's that narrowly tailored connection between the individual and the person that prosecuted the crime. And then the burden was put on the state's attorneys to actually provide notice to the victim. And in conversations with victims, and I'm sure Jennifer can speak to this, it felt like maybe there wasn't enough understanding on the victim's part that they could then kind of make it clear to the state's attorney their position, which is why we added really explicit language that specifically allows victims to submit a written statement. So that is how we've tried to stay true to HIPAA and the Vermont statute, but also allow victims a voice. Does that answer your question?
Yeah.
Okay. And so that's all I was going to talk about, unless you had other questions. I know those were just the two things that you wanted to share.
Yeah, I'm hoping that Jen Perlman and others can shed light on whether, they feel it's adequate. We have Tim Waters-Dumont from the state's attorneys to also speak, and Stuart Sure a little later. So are you going to be available for any other questions that might come up during the debate?
Yes, absolutely. And I thought I was going a little later, so I had more prepared to be responsive to other people's testimony. So yes, I will definitely be here and happy.
Jen wanted you to go first.
Yes, we talked about that because we wanted to make sure the victim notification piece was clear. Yeah.
We didn't think we'd get off the floor till 11, and we got off earlier. So.
Yeah.
That's Senator Baruch's fault. Senator Hashim has a question.
Hi, Karen. Thank you for the testimony. I have just one technical question that also might end up being for Tim, but I'll just pose it now. I'm just trying to be mindful of how this will be read by different panels or judges further down the road. And so I'm looking at page 2, line 4, where it says pursuant to 13 VSA 7553 and 7553A. And I was wondering if instead of an and, that needs to be an or, because there's two different types of hearings, and would a violation that would come under this panel, would it have to meet the criteria for both of those types of hearings, or one or the other?
Apologies. Can you say where you are again? I was trying to pull it up quickly.
Sure. It's page 2, draft number 9.1, page 2, line 4.
I wonder if I have a different. Oh, you know what I have up is Katie's new version. Okay, sorry. Line 2, page 4.
Sure,
okay.
Line 4. Line 4, page 2.
That's a good question and I am not sure. That may be a better question for them. I think that's language we had from last year. And so I don't remember if there was something specific about why we had an and versus an or.
Okay, thank you.
Sorry.
I'll also ask Tim or Ledge Counsel, and then just want to make sure that it's interpreted properly
Yes.
down the road. So thank you.
Good. Any other questions for Karen? Karen, thanks so much.
Yes, thank you for having me.
Jen Pullman from the Center for Crime Victim Services, the Executive Director. Good morning.
Good morning. Good morning, Senators. Thank you for your time. For the record, Jennifer Pullman, Executive Director of the Vermont Center for Crime Victim Services. And yes, Karen, Attorney Barber and I did speak, and we felt that it made sense in terms of the flow for her to present ahead of me with relative to the language impacting DMH. I do want to say that in addition to being the director, I also was the vice chair of the Act 27 working group. And I also want to really send a shout out to Senator Sears and Senator Lyons. Senator Sears described this as a summer working group or summer study committee. It was far from that. It went through up until the very end of November, meeting every other week for 2.5 hours. And it was probably in all my years the most challenging but also productive working group that I've ever been on. So I really appreciate the time the senators took to work on those issues. I did include that report on the committee page along with the letter submitted on behalf of the Vermont Center for Crime Victim Services in support of that report. Briefly, because I know we're short on time, I do just want to say for us, the context of these conversations that also began with Act 57 and S3 is really what happens to a victim who's experienced the same really serious harm, but the case goes a different route. So as you well know in this committee, under Title 13, victims have a long list of rights. But when it goes the other route, when there's a competency issue or an insanity issue that's raised, victims receive no information. And that really was brought out starkly, and again, I believe before this committee, when Joanne Kortendick, whose sister Kathleen was killed in Burlington in 2010, their family received absolutely no information until they found out that he died 9 years later. So for 9 years, they were in the dark. And that's not unusual. So it was really important for us as we've taken part in these conversations to really think about, are there ways that we don't have to have this stark dichotomy, that victims can receive basic notification and some basic information around discharge in order to keep themselves safe that doesn't impact on the individual in terms of any privacy issues, and have a right to be heard in some way that doesn't involve them in a confidential process, in the same way that we thought about this when we passed the juvenile, as I think about it, omnibus bill under S224. We can't have carve-outs. It doesn't have to be this stark dichotomy. So in terms of the specific language before you, I was very thankful to meet with Attorney Barber yesterday, along with 2 victims who had some concerns, and really to iron out that these 2 changes that you see on your committee page. One was just to be really clear that a forensic facility was included in the definitions and the mental health provisions. As you know, there were changes under Act 57 that describe what facilities were and such, but these predate what took place or is taking place in this particular proposal. So we just wanted to make sure that it was clear that forensic facility was included in terms of a discharge provision and notification. And then the changes that you see with respect to the opportunity to be heard, I appreciate Senator Vyhovsky's concerns, and again, working with Attorney Barber was really helpful for us to understand. And currently, under Act 57, there were changes made to Title 134822, wherein the Department of Mental Health actually has more expansive obligations to notify a victim, which are not just about concerning relative to the discharge of somebody from a facility, but also when a person elopes from the custody of the commissioner, which is very important in terms of providing safety, and when they're discharged completely from the care and custody. So they already have these responsibilities in statute. The change that you see in the proposal that Attorney Barber spoke to would simply allow a victim to be able to submit something in writing, or, contact the prosecutor's office, the victim advocate, and just share what their experience was. So it's a very limited ability that does not allow a victim into a closed courtroom setting, does not allow a victim to have this information. And the notification is strictly related to a person's basically comings and goings. It has nothing to do with what treatment that person's receiving or any other piece that pertains to their mental health or competency restoration. The one piece that's remaining, and I think it would probably be very helpful just for me to sit down with Attorney Shore, is when we looked at the responsibilities for notification, again, DMH already has more expansive responsibilities in terms of informing the state's attorney, who can then inform the victim about certain comings and goings. Again, I'll use that expression. And for me, the one piece that's of note is, again, that time when somebody elopes. And as the Senator Sears, you may remember, there was a discussion about the number of times that some of these folks who were thinking about is potentially appropriate for forensic facility actually do elope. And that would be something that, again, I don't want to take the committee's time to hash that out, but I think that Attorney Shore and I could come to a place where we could have something agreed upon in that area. And finally, I do want to really thank the committee for victims of crime, survivors of crime. The number one piece in this whole process that is the most meaningful, and we know this from a national survey that was conducted by the National Crime Victims Law Institute, is that they were heard. Not what happened, not what the outcome was, but that they felt that there was a process that allowed them to have a voice. So on its face, these may seem perhaps like minimal changes or small changes that are not obtrusive, but they make a huge difference. A victim or survivor should not sit for 9 years with no information about whether somebody's out or in for 9 years, then only to find out that that person died. We think that these changes that are proposed in 192 are very important, and we fully support them. Thank you.
Thank you. Any questions for Jen? Jen, pretty clear, and thank you very much for your time.
Thank you.
And thanks for, being the voice for so many of the victims of crime on that special committee, or whatever, the working group. I guess we did work. And it was an important role that you played. Thank you.
Thank you. I appreciate that, Senator Sears. It's helpful to hear that on tough days. So thank you.
You're welcome. The next witness is Timothy Lauders Dumont. Did I get the Timothy correct?
Yes.
Sometimes
Yes, Your
I
Honor.
fouled a lot of Lauders.
It's who knows what the original pronunciation was at one point or another. The umlaut dropped at one point, I think, a couple of centuries ago. Tim Lauders Dumont, the Department of State's attorneys and sheriffs, and it's always helpful going after Jen, Executive Director Pullman, because she brings not just the history, but experience working with so many people over the years. And some of my comfort level around victim pieces are directly correlating to how comfortable she is. So hearing her comfort level on some of the changes, I haven't had the time to go through the bill in its entirety with some of the stakeholders in our department or the changes this morning. And so what I wanted to do was highlight 2 submissions that I have posted on your committee page. One is a submission for the working group that you were on and that Jennifer was on, Mr. Chair, this summer and into the fall, S89, but I think it was Act 27.
Yeah.
So that's on your committee page, and what it does is it highlights some of the reoccurring points where prosecutors have a lot of consensus. And so we know that DMH, Dale, AHS, Legislative Council all have the opportunity to look through that. And what I would say about this bill right now is that there's some pieces that probably need some tweaking. This is the first time we've come in on this topic this session. We didn't come in on Senate Health and Welfare. And I know it was it was, the process still had a lot of conversation over there. So we appreciate that Chair Lyons doing the work, the due diligence she did, and we appreciate that we've come in today. As to the notification piece, that we appreciate any belt and suspenders that make the statute very clear for regular folks to understand what the statute says. So as you were saying, Senator Vyhovsky, what does that notification process look like? Victims being able to read this new bill and say, okay, so I can do this victim impact statement. My state's attorney will get notification, or the Attorney General's office, and then I can submit something and be heard. That's good, because even if it was implied in some manner in some other part of statute, it's fine. And as Judge Zone often says, simplicity for judges who may be new, simplicity for prosecutors who may be new is great. Not everyone has institutional knowledge. So I think we're supportive of some of those changes that come in there. A couple broad points that I did want to raise and say that I think this should keep moving along to the House, and it's possible we'll have more tweaks that go along the process. I don't want us to be the reason that it doesn't move along. But the 90-day piece, I just wanted to note that there's been a lot of discussion about the 90-day piece, about the review that will happen every 90 days. Putting that in practice, what does that look like? That could be an enormous amount of court time that takes place where you're bringing up the same folks, the same interested parties, the court time, et cetera. The due process requirements that are applicable to this type of area is the annual review. And so 90-day is something that a Supreme Court decision put in place, but the due process overall requirement is that annual review. This bill codifies something that we wouldn't necessarily agree with as to the 90-day, and I just want to bookmark that. Broadly across the state, the 90-day review is something that may not line up with someone's ability to actually engage with treatment. 90 days may not be long enough for some of that, but it doesn't also forego the opportunity for folks to file or otherwise build into this opportunities for review.
I have not reviewed this, Tim. Where do we find that, the 90-day review? What section is that in?
So the 90 days is at least on page 6, is I believe one of the first mentions of it, but it's throughout. Whenever there's an opportunity for the review that's going to take place, it's a 90-day period. It's been set for the commissioner of the respective department here to review this, and it's also set really for that opportunity for the order to either lapse or for the opportunity for continued treatment to occur at that 90 days as well. So prosecutors are comfortable with the annual review, which provides for the parties to either file something for review, an individual saying, hey, after 30 days, or sorry, after 91 days, we want to review. The annual review is something that our prosecutors with many years of experience believe is a better ceiling, so to speak, and then there can be review periods throughout. But building in every 90 days for these very serious cases, the cases contemplated here are the life offenses that are subject to hold without bail, and the crimes of violence that are subject to hold without bail. So very serious cases that could take up a huge amount of time every 90 days. I just want to flag that we believe the annual review should be what this bill looks at for a variety of practice, but also the due process requirements don't require 90 days. That's something you're building in here. And this is reflected in the comments we submitted on the site. The second point I wanted to bring up is that just as an overarching thing, whenever and we talked about it already, but just because a victim has notice doesn't mean they're aware of some of the more detailed pieces, and that notice piece, that opportunity for the victim. And sometimes it isn't just a specific victim, as we talked about. Sometimes it could be family. Sometimes it could be a crime that involved many, many victims. And so it starts to feel more like the public. There is a little bit of that balance where people sometimes want to know what is going on with this case. Someone, fired a gun at a public location. It isn't just, there isn't always just the one victim involved. And I just want to note that there could be some balancing that comes into play here about, it could be that lots of folks feel impacted by individuals who are subject to these types of pieces of information. And it's important to note that we are hearing from prosecutors that the criminal court, where the case took place, may be in a more shielded fashion, but the criminal court is the better location for a lot of these situations because of the nature of what's underlying their reason for
make that argument in the House.
Yeah, and I appreciate that. It's just the first opportunity to be heard on this.
I understand,
Yeah.
but I think that clearly we're more concerned with, you know, the victim notification piece and the role that, well, I will comment that one of the first things that we had to look at, and I see on page 2 of your report, that a judge who ordered to the facility, that was hard because of the disparity in what we've seen judges do. If we give the judges the control over that admission, you may have no room in the inn, very frequently, because judges may be more cautious, and DMH has the expertise, and that was the reason why the study committee and I supported DMH or Dale in determining the placement. But I will say that my biggest concern is to make sure that arrangements made between the defense bar and the state's attorney, like in the Pronto case, where there is notice and there is the rehold if they're released, so that they're not out in the community. That is, or at least they're in a, I shouldn't say they're not out in the community, at least they're in a setting where they're some control. Some of these individuals are extremely dangerous. You know, his alleged crime was slitting a woman's throat in broad daylight on Martin Luther King Day in Bennington at the middle of the morning.
Yeah, and one piece I wanted to note about sort of the functionality of this is, I believe there's reference a couple times to 10 days, at least 10 days from page 26 here, prior to the effective date of any administrative discharge, the commissioner from commitment placement facility, or 10 days prior to expiration, shall provide state's attorney, et cetera, with the information. If we are going to be coming forth as this statute change indicates, to potentially present evidence, find an expert, whatever, 10 days may not be enough time. And so as a potential flag for the House side, something that we may bring up is that for both defense, prosecution, et cetera, 10 days may not be sufficient to get an expert secured and all of that. So just as a flag. And then another piece, the purpose of the public safety panel, from our view, should be to provide analysis to the court. I know that we've just sort of discussed some of that, whether it's the court ordering or whether DMH is applying. We certainly believe that should be the court ordering, and then figuring out the logistics on the other end, the entrance in terms of the ability to actually have someone enter.
The concern is overload of
Understood.
Who may or may not have the level of expertise in determining who should be there.
Understood. I think circling back to the comment that you made, Senator Hashim, about the and or the or, we definitely think that should be an or, because and would indicate that it's a two-part test as to the 7553 or 7553A. And while there are certain circumstances where we could apply for both, there are also circumstances where something is really just falls under one of those pieces potentially. So I think it should probably be an or, to be clear for folks who are trying to figure out what it says. Again, we've posted some of the comments that have remained pretty consistent throughout on this topic area. Certainly last year you had indicated a July 1st, 2024 opening date, and I think you're working on the logistics, Mr. Chair, of trying to get something operational, but also trying to get all the rules, et cetera, in place. So certainly we appreciate whenever the forensic facility can be up and running, because as you stated, what's happening now is individuals who are not being served well by an incarcerated setting in any fashion are languishing, and we think that small group of individuals could really benefit from being in that non-incarcerated forensic facility. And it's not good for the entirety of the system when folks are not doing well in an incarcerated facility, as you heard over the summer and the fall at length. The other thing I wanted to flag, which I'll flag on the House as well, is labeling these as ONHs, orders of non-hospitalization. Some of the prosecutors that I've spoken with across the state are a bit uncomfortable with that. Perhaps not just because of the nature of it automatically triggering the O&H process, what you're building in, but because these are forensic facility commitment orders. It not only is it a bit of a misnomer, but an O&H is also something that we have in place right now that we don't think is working particularly well. And so if we're building something, a new pathway into a commitment of any kind, calling it something different, forensic facility commitment order, something like that, is helpful. And it also may lead to new processes that are better than the current O&H process, at least in terms of our lens, right? We understand there's another very important lens that folks are looking through when they're looking at these circumstances, which is not always the criminal justice lens. It's that mental health systems and criminal justice systems overlapping, interacting. And I think that's why there is so much debate and conversation about all this. I didn't have much else to say other than the bail provisions probably would be to say that where bail is not available. I would just use, if I were the drafter here, I would just use the direct language from 13 VSA 7553 or 7553A. Bail is available in every single crime in the state of Vermont. So to say not available is not comporting with law. We would say where that applies, right? Where 7553A or 7553 is applied.
I have a similar.
If you could send that to Katie,
Victor McClellan, yeah,
I'll flag on behalf of the Senate Judiciary.
Yes, I will flag that for. And I think the intent is clearly where.
The intent is to use those,
where hold without bail applies.
Hold without bail is possible.
Right. And I don't have any other questions. I appreciate the time, and as noted, the legislative process is condensed so much that it's hard to get into every committee. But
that you're generally comfortable with the changes or suggestions you outlined in your memos.
Yeah, I think I'll have to do more of a firm vetting with some of our folks, Jared Bianchi and others, who's not available today, who have been engaged on this for a number of years prior to me. So I want to do more of that vetting, but I don't want to also get in the way of this moving forward.
Well, I remind myself and the committee that last January, a year ago, the administration, the establishment of a forensic facility was a large priority for the administration. And that this is the culmination of that. We established it, and then we had the working group on whether or not those with intellectual disabilities should be able to avail themselves of the treatment there. But some of the details are still being ironed out, obviously. But it is a high priority of the administration, and I think the legislature has agreed that, again, as an alternative to the corrections process, current process, which is not ideal for the victims, not ideal for the patient, not ideal for corrections.
Yeah, ironing out. It seems like we're in that process.
That's right. It's a long haul. Thank you. Ed, any questions for Tim?
Did I address your question?
Yeah, thank you.
Thank you.
Stuart Scher is our final witness on this, and then we're gonna go to S58 with Michelle. She's volunteered to come down to 11:15 and help us with certain sections of that bill. So, Stuart?
Good morning, Senator.
Morning.
Thank you so much. For the record, Stuart Scher, I'm General Counsel for the Department of Disabilities, Aging, and Independent Living, also known as DALE. And I want to thank the committee for its time in looking at this bill. It's been a long road so far, as you know, Senator Sears. We did spend a lot of time over the summer and fall with the Act 27 working group, and we spent a lot of time in Senate Health and Welfare. I should start by saying that DALE fully supports this effort to include individuals with intellectual disabilities at the forensic facility under the limited circumstances set forth in the bill. And I also want to say that I want to comment specifically on a couple of things that Attorney Lueders Dumont referenced in the bill, and then also some of the victim provisions in the bill. So first of all, Attorney Lueders-Dumont referenced the fact that there was some concern about the 90-day review of orders for commitment. And I want to be clear that in the context of the population of individuals with intellectual disabilities, there is no automatic 90-day review of those orders of commitment. There would be an automatic one-time 90-day review of an individual's placement at the forensic facility to make sure that it is still the least restricted environment to meet the needs of that individual. But as far as commitment itself, commitment orders may be up to 1 year. And Dale testified in Senate Health and Welfare that that was important not to limit that to 90 days, requiring a review every 90 days, specifically because individuals with intellectual disabilities are not subject to the involuntary medications, for example, that individuals with mental illness would have available to them, which could potentially change those behaviors in a shorter period of time. Individuals with intellectual disabilities are going to take a significantly more time to change their behaviors, and therefore establishing a 90-day review of that individual's need for continued custody would not be prudent. So that's the one point I wanted to make. But with respect to the victim's notification provision, Dale, I do expect that Attorney Pullman and I will have an opportunity to speak and should be able to come up with some language that we can mutually agree upon. I will say that as an overarching theme, Dale fully supports the rights of victims to receive notice of discharge from custody or the forensic facility or both when they're being considered by the court or by the commissioner for an administrative discharge. We believe, however, that there is some ambiguity in the most recent draft of this bill as to who is to provide that notice to the victim when a judicial review is to occur, and that's in 8847B2B. And Dale also notes that the prosecutor and the victim would have a right to file a position with the court as an interested person concerning whether the person's discharge from placement at the forensic facility is appropriate. That's the current language in 8847B2B. But the ambiguity there is, what does it mean for the victim or the prosecutor to say that the discharge is no longer appropriate? What standard does the court apply in considering the position that discharge is not appropriate? And who bears what burden of proof? So I would ask the committee to consider the fact that in light of the proposed amendment that we heard about this morning to the mental health statute, whereby victims would have a right to submit a victim impact statement, Dale proposes that there be an alignment in the statute governing those with intellectual disability. So 8847B2B could be revised by striking the phrase "may file a position with the court as an interested person concerning whether the person's discharge at the forensic facility is appropriate," and replacing it with "may file a statement with the court containing their position concerning the person's discharge from the commissioner's custody or placement at the forensic facility or both." That would align more closely with the DMH statute, and I think it addresses some of the concerns about what is the court's burden of proof. In fact, what it would do is it would give the victim and the prosecutor a right to be heard through the submission of a position statement, but it wouldn't appear to require any further detail in the statute about how it would be considered by the court, how much weight to be given, who bears the burden, and so forth. The same argument we would make with respect to a proposed administrative discharge by the commission, and that's in 8847C2B. So B2B is the court's proposed discharge from custody, and C2B is the commissioner's proposed discharge. And as Attorney Lueders-Dumont referenced, when he was speaking about the 10-day notice period, how that might not be enough to have the prosecution and or the victim line up expert witnesses, that gets to the point that I wanted to raise here, which is, again, the statute is currently silent as to what that burden is and what the court is to consider. If in the alternative, the language simply states the prosecution and or the victim have a right to submit a statement to the court, which shall be considered by the court, there would not be that issue of having to determine what that burden of proof is. The 10 days of giving time for the prosecution and victims to call expert witnesses would no longer be an issue, because the input from the victim and the prosecution after getting notice would be to submit that statement to the court. So that's the position of Dale at this point. But again, I do look forward to speaking with Attorney Pullman and Attorney Lueders-Dumont as well.
Well, it sounds like these things can be worked out rather.
I think so.
Expeditiously. I don't think they're major hurdles.
Not at all.
Questions, Stuart? Stuart, thank you so much for being
Thanks,
here.
Senator. Good to see you.
Good to see you. So we're gonna move on to S58 in about 5 minutes. So why don't we take a short break? Get back at 11:15.